Thank you very much for joining today's webinar on how to master AI regulation and how to implement the AI Act. Thank you very much for joining us today. I am Boniface de Champris from the Computer and Communications Industry Association, and I am delighted to moderate today's discussion. We have the delight and pleasure to have two leading AI policy experts with us here today to present and discuss the findings of very recent and timely studies. And we are all looking forward to learning more about it. They are very timely because, well, I think it's demonstrated by the large number of participants and the huge interest in this webinar. But also because the European Union has recently adopted its Artificial Intelligence Act, and because regulators and legislators around the world are looking into ways to address AI in a way or another. So without further ado, allow me to introduce you to our esteemed speakers. Professor Dr. Martin Ebers is the president of the Robotics and AI Law Society, as well as associate professor at the University of Tartu and permanent research fellow at the Faculty of Law of the Humboldt University of Berlin. Professor Ebers is the author of a recent study entitled Truly Risk-Based Regulation of Artificial Intelligence, How to Implement the AI Act. So we will hear about it more in a couple of minutes. And Brian Williamson is partner at Communications Chamber and has conducted a significant amount of work at the intersection of technology, economics, and policy. Mr. Williamson is the author of a study published this morning and entitled Aligning Regulation and Artificial Intelligence. Welcome to you and thank you for joining us today. Before we start with the presentations from the authors, I just wanted to briefly tell our audience that we will start with around 20 minutes of presentations of the two studies, and then we'll have plenty of time for Q&A and discussion. And in order to ask your questions, and this is maybe not the most user-friendly way to do it, but I will write in the chat how to do it. So if you click on the activities button at the bottom right of your screen, you can find a tab Q&A, and there you can, and we already have a question, so this is great. And there you can ask your questions, and I will pick them throughout the session. So please ask your questions, and yes, don't be shy. Professor Ebers, I suggest that we start with your presentation. So the floor is yours. Thank you very much.
Yeah, thank you so much for the warm welcome. In this very short presentation, I will present the findings of the most recent study of mine called Truly Risk-Based Regulation. In case you're interested to learn more, you can find on the internet the entire study, which is about 30 pages, but then there's also a standalone summary that tries to summarize the main points on 2 pages. So basically, I look into the AI Act risk-based approach, and the AI Act sets out in one of its recitals this risk-based approach as follows. In order to introduce a proportionate and effective set of binding rules for AI systems, a clearly defined risk-based approach should be followed. That approach should tailor the type and content of such rules to the intensity and scope of the risks that AI systems can generate. And then the next sentence is basically about what kind of categories the AI Act introduces. It is therefore necessary to prohibit certain unacceptable AI practices, to lay down requirements for high-risk AI systems and obligations for the relevant operators, and to lay down transparency obligations for certain AI systems. So basically in my paper, I make 3 points. The first point is that I try to explain why the AI Act is not fully based on a risk-based approach. The second one is that I look into how to implement the AI Act, and there I show that the AI Act provides for sufficient flexible tools for the European Commission, for the member states, and for other actors here as well, to implement the AI Act in a way that follows more closely the original idea of a risk-based approach. And last but not least, the last section then of my paper is about what lawmakers outside the EU can learn from the AI Act. So why is the AI Act not based on a truly risk-based approach? So first of all, a risk-based approach requires not only an analysis of the risks, but also of the benefits, because at the end of the day, we take certain risks because we think this technology also presents significant benefits. And it is also clear, I think, that the underuse of AI in certain fields, as for example in the healthcare sector, can also be risky as such, because if you do not use AI, and it can be shown that AI systems are more effective than humans, then of course we have a problem. So the entire architecture of the AI Act is based on risks, but not so much on benefits, and that is clearly an element that is missing. Then also there's limited reliance on empirical evidence. Actually, the lawmakers, the European Commission, but also Parliament and Council, never made really clear how they came up with all these risk categories in the first place. So there is a lack of empirical evidence here. It is clear that the AI Act has in one of its articles a long list of criteria that should be taken into account when the AI Act is going to be modified. So when the legislator, or to be more precise, the European Commission, changes the AI Act later, then it has to provide empirical evidence. But the original risk categories actually lack this empirical evidence. Then the AI Act is based on predefined closed risk categories. So top-down, certain risk categories are set out in the AI Act, and that is not based on concrete use cases. And the problem here is they are so broadly formulated, especially the high risk use cases in Annex 3, that there is the danger of over-regulation. And then also it creates somehow a sharp rift between high-risk categories, which are very intensely regulated, and all other, maybe even also risky AI applications. Then the regulation of general purpose AI models is somehow an alien element that was only later introduced and does not really fit the risk pyramid. It's also interesting to see in its first webinar that was conducted by the European Commission's AI office. They presented this risk pyramid, and then the regulation on general purpose AI models as something separate. Because if you look more closely into these rules, then you find out that not concrete risks are here being regulated, but rather a technology. And also, when the AI Act talks about systemic JEPI models that provide, that present a systemic risk, the category of systemic risk is also not very convincing. The AI Act also is based on an overly broad AI definition. So not only AI systems based on machine learning, but also more predictable technologies fall under the definition of AI. And that leads then to the consequence that not only machine learning-based AI systems, but also more predictable AI technologies are subject to the same strict rules. The AI Act is a horizontal instrument that does not replace the existing EU laws, but basically applies on top of it. And that leads to double regulatory burdens, again, contrary to a truly risk-based approach. And then also, because it's a horizontal approach, we will see in member states different agencies that enforce for one and the same case different laws. And that leads to an overlap of enforcement tools. So against this background, I developed in my paper recommendations on how to implement the AI Act. And I show that the AI Act indeed provides for sufficient tools to interpret and to specify the AI Act, and even to amend the AI Act, that is to say, to change the AI Act via not only guidelines, but also delegated and implementing acts, codes of practice, and harmonized standards. And for all of that in the implementation phase, I think it is very important that implementation follows the risk-based approach, because the risk-based approach is the guiding principle for implementing the AI Act that follows, first of all, from the ratio legis of the AI Act, the recital 26, but also more generally, the risk-based approach is based on the constitutional principle of proportionality, and therefore also primary law strikes in favor of implementing the AI Act following a risk-based approach. And beyond implementation, what is also necessary is a revision of sector-specific EU laws that brings the whole legal framework of AI in the European Union in line with a truly risk-based approach. Last but not least, my last section looks into what lawmakers outside the European Union can learn from the AI Act. So that is mainly about the so-called Brussels effect that goes back to a book by Anna Bradford, where she looked at the worldwide success of the EU General Data Protection Regulation. So the Brussels effect actually happens if lawmakers follow voluntarily the EU legislation. And here I show that it is not very likely that the AI Act will trigger the Brussels effect like the GDPR. There are different reasons. I think in the discussion I can explore that, but one main factor is that the GDPR is a very homogeneous piece of legislation where it's really about one policy problem, one fundamental right, the right to privacy, data protection, whereas the AI Act is about many different things, from facial recognition systems, social scoring, AI, medical AI, to AI in the judiciary. And then also it is a very complicated piece of legislation. So you cannot just copy and paste the AI Act as you might do with the GDPR. Last but not least, I think there are also a lot of reasons why the AI Act shouldn't trigger a Brussels effect. And I think that is basically because different countries and citizens are affected differently by AI due to the respective economic, social, legal, and political situation. So the situation outside the EU might be pretty different. Also, AI regulation is still in its early stages, and it is really unclear what the social and economic consequences of the AI Act will be. Last but not least, the risk-based approach of the AI Act is also ill-suited to protect human rights. So there is a certain clash between risk-based and rights-based regulation, and the AI Act tries to protect also human rights by risk-based regulation. And then, and that is my last argument here to conclude, the AI Act does not follow a truly risk-based approach. The risk-based approach is actually a good approach to regulate AI. However, the AI Act really needs to implement more closely in accordance with a risk-based approach. And also, therefore, lawmakers outside the EU should not blindly copy and paste the AI Act.
Thank you very much, Professor Ebers. That's very, very interesting, and also, as you say in your paper, that's nothing that cannot be remedied in the implementation phase, which I think will be very important moving forward. Mr. Williamson, I give you the floor. I think we will zoom a bit out from the AI Act and look at AI regulation more generally. Please, the floor is yours. And yes.
Thank you, and good afternoon. I'll say a little bit about my focus, as was mentioned, is somewhat different. I don't take having an AI Act as a given and think about how to apply that in the best possible way. I really ask the question, how should we think about regulation of AI, assuming you've not really starting with an act? What should you do? And I draw some parallels with other technological revolutions that have happened in the past. So I've got about 6 points to make, and the paper that I've done is published and will be shared with participants following the webinar. The first point I'd make is AI is a general purpose technology like steam, electricity, and computing, and you would expect it to produce a kind of wave of productivity and income growth. That won't happen immediately, it'll take time, but it does appear to be a powerful technology which will be very beneficial for society. It also involves the invention of a method of invention, and we're seeing the early application of that in life and material sciences, which will fairly quickly generate benefits, for example, in healthcare with the development of medicines, for example. So there's a lot of benefit there. And if we delay or somehow impede the development of AI, we'll slow or forego those benefits. So I think we have to keep that in mind in thinking about risk trade-offs, that actually slowing AI down involves some big costs. The first point I'll make is that applications of AI are regulated even if we don't have a law of AI. And to give an example, if you think of a new medicine, let's say a new medicine or prospective medicine was identified using AI, it still has to go through the usual process of approval, including clinical trials. So, and if you think of any specific application of AI, it's probably regulated in some way, because we regulate activities where there is risk. And in a sense, this relates to the point about being specific about risk. We have built up over time a regulatory framework which does regulate risky activities, and it may be imperfect, but it's very, very granular. So trying to do that with a kind of top-down approach, a law of AI, is quite challenging when you've already got regulation in place. So I think that the focus shouldn't be on trying to develop, the term future-proof law of AI. It should be on aligning regulation and AI over time. And it won't be a one-off exercise, it'll be an ongoing challenge. As technologies evolve and as the application of existing law is tested and clarified, regulation may need to change. So we'll start with existing regulation. In many instances, that may be fine. It may work perfectly well for AI as well as other ways of producing the same activity. But we will identify problems, but not immediately necessarily. to give this the analogy to steam, we didn't have a law of steam. At least I don't think we did at the start of the Industrial Revolution, and I think that would have been a mistake if we'd done that. There was lots of innovation in relation to steam engines, but also complementary technologies. And the one I'll mention is rail, which I think came at least half a century after James Watt had patented the steam engine. So if you had been writing a law at the beginning of that change, you wouldn't have anticipated the question of rail safety. That came much later. But ultimately, the UK and other countries did regulate for rail safety. So I think there'll be issues like that where AI is used in a way that is novel, isn't subject to existing regulation in some way, and we'll need to think about that. But in the first instance, I think most of the applications of AI will be regulated by existing laws and regulations. The other way this could go in terms of adapting is that if you take the medicines example again, it may be that if you find a prospective drug using AI, because of the predictive power of AI, and AlphaFold 3 is a recent example of that kind of technology, that you might be able to shorten the drug approval process once you've proven that AI has sufficient predictive power to perhaps reduce the need for trials and other tests. If you deeply understand the impact of a prospective medicine on the human body, you may be able to shorten some of that approval process. So it may be in the future that you would want to change the drug approval process or pipeline. You may also want to change it just to deal with the scale of prospective medicines we may see in the next 5 years, because AI is already identifying many candidate medicines. So we may need to accelerate or deepen that process. So I think the real challenge is adapting existing regulation. The next point I'll make is that the default position, in my view, is that AI is over-regulated. And the reason for that is that many safety laws are not technology agnostic. They tend to be framed in terms of licensed individuals rather than performance. An example of that is if you want to drive a car, you need a driver's license. If you want to allow autonomous vehicles, you have to kind of create an adjacent framework. And that leads to delay even if autonomous vehicles are safer than the average driver. The US has made some progress on this, but it's slow globally, the approval process for autonomous vehicles. The fundamental point is that you just can't use AI in a lot of applications because we've just framed existing regulation around people. The other example is occupational licensing. And the US has, I understand, more of this than Europe. About 30% of occupations in the US, you need a license to practice them. AI won't be able to do any of those jobs, not unless we change the rules. And an extreme example is magicians in Nevada. You have to have a license. You have to be at least 21 years of age. So AI can't even do magic. To prescribing medicines, actually, where we might want to create some category where an AI, if it is sufficiently good at diagnostics, can go straight to prescribing a medicine for someone. Maybe that's a little bit in the future, but it's the kind of example where we need to broaden the process beyond one that requires a qualified individual. So I think AI, because of that, is over-regulated, indeed is prohibited from performing about 30% of the tasks in the US economy. Less so in Europe. Europe actually has less occupational licensing than the US. It's one instance where there's less regulation in Europe than the US, is my understanding. Just turning to models, I think we have to be careful not to hamper the development of better models. Existing models are useful, but they will get better. And some of the propositions that are on the table, I think, would slow down that progress, which seems counterproductive. One of the propositions is compute limits beyond which you face more onerous requirements. And I kind of think of that as, is more intelligence bad? It seems to me more intelligence is good, if I can use that term intelligence loosely. I think another example is some of the ideas under discussion would limit the scope for models to use publicly available data. And it seems to me that would limit their ability to reflect human knowledge, but also human culture. So if we're going to have these general models, one way I think of them is like public libraries. You wouldn't want to start from a position where you said all the books that contain misinformation or bias, we'll take those out, because that would be a pretty large fraction of the books in a public library. That is part of our history, it's part of our cultural knowledge. And I think we want all of that in there. Now, maybe in a particular application, you want to avoid misinformation or bias. That's fine. But I don't think you necessarily want to preclude information from being used for training purposes, because a lot of the knowledge we had historically, we now think of as false or biased, for that matter. So I think that it should all be potentially in the model. I'll come on to the risk point, and you've heard quite a bit about that already. The point I want to make is that the way risk has been framed in the debate about AI, I think, is one-sided and misleading to an extent. First of all, AI may be risk reducing. And so if we identify long lists of risks and we delay things because we've done that, we're kind of missing the other side of the ledger, which is there's many applications of AI that I think will reduce activities that are quite risky at the moment. Healthcare is risky. And so is transportation, for example. The next point I'll make is that there is concern that AI will be used for things like hacking for harmful activities, and I think that's undoubtedly true. Criminals will use any tool available to them. But if you take the case of cybersecurity, what is the net effect of AI? It'll be used defensively as well. And if we kind of limit the capabilities of models that are publicly available because we're concerned about bad actors using them, well, they'll probably get access to models that are not safe anyway, and will limit our ability to use them in the defense. So I think you have to kind of think quite carefully about what the equilibrium outcome is when AI is used by everybody. And you don't want to tie the hands of the people who have good intentions. There's another point which I think is a little bit more general, which is that all technologies may be used in harmful ways. But that doesn't mean to say you should insist that the technology itself is safe. That may be the wrong thing to focus on. I'll give an example of knives, which are very useful in the kitchen, for example, but they are also used by criminals. And we don't insist that knives are blunt because of knife crime. We do other things. We maybe have age restrictions on who can buy a knife. We have criminal penalties for the use of knives in criminal activities. So it's kind of a category error to focus back on a general purpose technology when you're thinking about harms. I think you need to focus on the harms and think about the best way to address those, which may not be at the technology layer. So I think I'll close by saying that personally, I don't think you need a law of AI. I think the key thing is to adapt existing regulation over time, and that's a big challenge we need to focus on. For those who don't have a law of AI yet, I think you can afford to wait and see what happens, for example, with the European AI Act. So don't rush into having a law of AI. Focus on the hard task of adapting. I'll stop there. Thank you.
Thank you very much. It's very, very interesting, and I have a lot of questions. I see we already have a few in the Q&A, and please, to the audience, feel free to ask questions. You can see in the chat function or in the chat how to use the Q&A. So please use it. I see, for example, one first question on how you feel about all the last-minute additions in the political negotiations on the AI Act, and whether this changes anything or makes the AI Act future-proof or not? And if not, at what point do you expect the AI Act to become outdated? And maybe I would even link it to the numerous tools that you are actually also looking into, Professor Ebers, the code of practice, the guidelines, and the many different implementation tools that the AI Act provides. Let me maybe start with you, Professor Ebers.
Sure. I mean, if we look on how the trilogue negotiations then ended, I think we can see both positive and negative things. Maybe like to start with a positive thing. So the legislators noticed that the high-risk AI systems categories in Annex 3 are too broadly worded. And then, as a reaction to it, they introduced this so-called additional layer that is now foreseen in Article 6, Paragraph 3, according to which a provider of an AI system that classifies as a high-risk AI system under Annex 3 still has the possibility then to show and to document that the AI system in question does not pose significant risks to health, safety, fundamental rights. So I think this is a good example. On the other hand, of course, you can find also some negative examples, and especially I think the provisions on general purpose AI systems, they were introduced kind of like in a panic situation when the European Commission and also the co-legislators realized that the original intended risk-based approach that looks at concrete use cases is not in the position to effectively then deal with general purpose AI systems. So therefore, the drafts that were discussed during the trilogue were really kind of like weird, and I think these are the provisions that we will also discuss very much in the future because they have not been really thoroughly drafted. Regarding your question of future-proof legislation, yeah, indeed, there are many tools. I mean, one minimum tool is, of course, just to interpret the AI Act in a way that is innovation-friendly. So it remains to be seen, for example, how the European Commission will interpret the notion of AI, because it is not really clear what is in and what is out, because Article 3 of the AI Act follows the OECD definition, which is very broad, and only the recitals try to narrow down the scope of application. And the AI Act now foresees that the European Commission will publish guidelines on how to interpret the notion of AI system. But beyond interpretation, there's also much more flexible tools, so-called implementing acts and delegated acts. So the European Commission, for example, has the possibility to look into the list of high-risk AI systems and then change it, this list, without undergoing this very burdensome legislative process.
Thank you. And maybe to you, Mr. Williamson, if you want to answer this question. And I also note that in your paper, you write that in a way to avoid unintended consequences from regulating technology that is rapidly evolving and very dynamic, the use of voluntary measures, but I think also flexible, let's say, regulatory tools can be a way, let's say, to diminish the risk of unintended consequences. Well, how do you see this in the AI Act and maybe more generally?
I think more generally, if I think about the issues that I've talked about, the fact that we'll need to adapt sector-specific regulation, and that's one way you can try and avoid unintended consequences. Is there is sectoral expertise within the sector-specific regulators, and they really need to be engaged in a dialogue with industry, including the AI providers, about how those laws need to adapt. And there are thousands of regulations that we need to be looking at and saying, you know, is it a priority to fix what are the priorities here? Some of them will have to change, some will be fine. So I think in that sense, that isn't something that the EU AI Act addresses. And in a sense it can't, because a lot of the competency for that is at the member state level. The Commission doesn't have the authority to do some of that. And I think that is a point, if someone from another country is looking at this and thinking this could be a template, that's one reason it's not a good template, is that the Commission, it's a federal system, and the Commission only has certain competencies. Whereas if you're in a kind of unitary country, you can address a lot of the other issues that I'm talking about from central government. The other point I'd make is I think there are things in there where you might say they're not future-proof already, or, you know, it could be my opinion. For example, it's the Act has limitations on the use of emotional recognition technology. And when I watched the ChatGPT kind of real-time chat demonstration, emotion was a key part of that. So if you're going to restrict the use of emotional recognition in, say, educational settings, it may be that emotional recognition is a key part of the computer interface. So I think it's understandable that there might be concerns around emotional recognition or harmful uses of that technology, but I don't think we were really thinking that we would be talking to computers in a fluid way, where actually having emotion in the conversation is a key part of understanding. So I think you could already identify things where you would say you might have framed that differently or narrowed it, which are, you know, are not future-proof. I don't really think it's possible to write a law of AI that is future-proof. Yeah.
Thank you. I think this was a very clear response. I see another question which is addressed to Professor Ebers, which is, and I think also interesting for the two authors actually. It is whether so since the AI Act essentially the obligations apply once the AI system is placed on the market, although there are also certain activities before that, but whether the assumption of the AI Act isn't that the benefits form part of the intended use of a system, and that the benefits will then need to be considered at the stage of the risk assessment. And I think that's, since we are touching upon the benefits, the two studies look into the benefits, which are very often, I think, overlooked. So maybe, Martin, I let you react to this.
Yeah, I mean, risk plays a different role at different stages. So what the AI Act does is that top-down, first of all, these risk categories are defined by the legislator itself. So the legislator already decided what is an unacceptable risk, and then leads to a prohibition, what is a high risk, and then leads to the conformity assessment procedure necessary to undergo for a provider of a high-risk AI system before it can be placed on the market, and then all the other risk categories. Once it is a high risk and it is classified as such by the legislator, then indeed at the individual level, the company, the provider of such a high-risk AI system has the possibility to assess more closely than the risks and also the benefits. So therefore, of course, benefits are not totally absent in the AI Act. But maybe to give you one example where it really matters. So it matters, I think, when we have a dilemma situation. So where we have on one hand, for example, in the field of medical AI, an AI system that is very efficient in diagnosing, for example, diseases, but is at the same time also very opaque, because it could be shown that especially AI systems that are based on deep learning are very efficient, but at the same time, they are very opaque. So we do not understand actually how they work and how they come up then with a certain prediction. So if you have a risk-benefit analysis present here, you would say, okay, here are the benefits of medical AI and here are the risks. But this is not really present in the AI Act, because once you have medical AI, then it is categorized as a high-risk AI system, and then you have a transparency requirement. And there are some people that say, well, the AI Act does not really mention here that benefits have to be taken into account, and therefore, maybe there must be a minimum level of transparency that we have to reach, and otherwise, such a system can simply not enter the market if it is inherently opaque. So that is just like one example that shows, because of the absence of a clear risk-benefit analysis, we cannot deal with these dilemma situations in a convincing way, which is actually getting back a little bit what Brian said, and his claim in favor of a sector-specific regulation, which is actually present in the European Union's medical device regulation. When we have medical devices, the medical device regulation clearly sets out that there should be a risk-benefit analysis, but at least not explicitly. This is the case here in the case of the AI Act, because the benefits are not really mentioned here.
Thank you. And I think this links also very well to another question, which I see, which is addressed to you, Brian, actually, which is how to strike a balance on regulation to manage actual risks on the one hand, while ensuring that regulation does not hamper the massive potential associated with the use of AI. And your study looks into the benefits or into many benefits of artificial intelligence. So I think, yes, you certainly have certain views.
Yeah, I think my key point on this question would be, don't regulate the technology itself, focus on the applications. Because if you regulate the technology, you'll almost certainly slow down innovation and it'll have unintended consequences. Whereas down at the applications level, I think you can, at least in principle, make the trade-off between costs and benefits or risks and benefits. It's when you try to regulate the models that you're kind of getting into trouble, I think, on this. Because you'll do something that you think is well-intentioned at that level, but that prevents a beneficial use downstream. I'll just make one additional point to reinforce this point about transparency as well, that I don't know if it's still the case, but certainly up until recently, we didn't understand the mechanism by which general anesthesia worked. Now, I don't think most of us would reject general anesthesia because we don't understand the mechanism. You can empirically show it works. So we shouldn't insist on this kind of mechanistic understanding before we use something. If it works, it works. And if we can show that it works, we should adopt it.
Thank you. I see another question, and please continue to ask questions. It's really great to see so much interest in these studies. A question maybe to you, Martin, whether the AI Act has an adequate framework for protecting the right to non-discrimination, which I think goes back to your point on risk and rates-based approaches.
Yeah, very good question. I mean, like, indeed, the AI Act tries or intends to protect fundamental rights. That is set out clearly in the recitals, in the articles. In case of certain high-risk AI systems, deployers even have to conduct a so-called fundamental rights impact assessment. And when it comes to discrimination, then Article 10 of the AI Act foresees for high-risk AI systems the obligation of data governance, and addresses also the problem of biased data training sets. Now, the problem is a little bit that the AI Act does not really specify when we have an algorithmic discrimination. Therefore, it is mainly up to the providers, but also to CEN and CENELEC, the two European standardization organizations that are already developing technical standards in this field that later then become harmonized standards, to deal with the question, when actually do we have a bias that leads to a prohibited algorithmic discrimination? And that's an open question, because we do have, of course, a lot of directives in the European Union, anti-discrimination directives, and we have a lot of judgments of the European Court of Justice interpreting these concepts, but they have never really applied to algorithmic discrimination. So somehow the AI Act leaves it therefore to the providers, and then at the end of the day also to the market surveillance authorities in the member states, and also to some extent to the European Commission, and then at the end the Court of Justice, to really concretize this rather fuzzy concept of algorithmic discrimination, which is not clear from the outset. So that is only like one reason why I doubt that the AI Act will really here protect fundamental rights, because of the lack of clear standards.
Thank you very much. That's, I think, very interesting. And this brings me maybe to one other question, which I see. So it took us a lot of time. We are probably still trying to figure out how to interpret and apply the general data protection regulation today. And it's, I read here, 8 years already, 6 years in enforcement. How do you see the market reacting to the AI Act, and also how long do you think it will take for the AI Act, or for the market actually, to really comply and understand this very complex piece of regulation, which, as you both indicated, interacts with so many other regulations, and maybe you may have recommendations on how to ensure that companies actually maybe comply easier, let's say, or have an easier compliance process in place. Maybe to start with you, Professor Ebers.
Well, that's really a very urgent question, no? We expect, that is at least my latest information, that the AI Act will be published in the official journal mid-July, and then it takes 20 days. So then the first weeks in August, it will then become applicable, and then there are still some timeline. So the first provisions enter into force and are directly applicable then already 6 months later. So that is to say end of January in February. And these first provisions are basically the prohibited practices. So companies then already at the beginning of 2025 have to have compliance mechanisms in place so that they check what kind of systems do they use, and does it fall under a prohibited practice in Article 5. And then there's also another provision, which I think many people oversee, and that is Article 4, that actually contains the obligation of providers and of deployers of AI systems to educate their employees. So AI literacy is actually key. So therefore, the existing compliance mechanisms in companies need to be critically revised already now in order to make the company fit to comply with the AI Act, which will be directly applicable already in less than 6-7 months.
Thank you. And maybe to you, Mr. Williamson, it's the same question, actually, but also linking maybe to your study and your case study on the AI Act specifically, where you look, for example, also into certain provisions which might already, well, for example, emotion recognition technology or general purpose AI, where you say that, well, we will already see implementation issues as the technology evolves. Maybe comments on this?
Yes. Well, I think that there may be aspects of the AI Act that, in view of technological change since it was kind of developed, you might start to think, well, we shouldn't be limiting that as broadly as we have. Emotional recognition might be one example. But I think the other problem is just if you combine the prospect of large penalties with uncertainty, and there is a lot of uncertainty at the moment about what compliance would mean, that kind of has two effects. One is if you're a startup, you might be cautious about doing something, overly cautious potentially. But if you're an existing provider of AI services, you may decide to withhold some beneficial services in the European market because of the uncertainty. So if you combine uncertainty and large penalties, those are two effects you would get: less innovation and potentially withholding of services. So I guess it's an urgent matter to clarify what some of these things truly mean. Yeah.
Thank you. And maybe a follow-up question directly to that, whether you think that the AI Act provides sufficient guarantees for leveraging self and co-regulation of artificial intelligence systems, and maybe the benefits you see in this kind of balance, if there is any in the AI Act.
Well, the AI Act is based on the idea of co-regulation, in the sense that the AI Act provides the basic framework, but then it is mainly to CEN and CENELEC, the two European standardization organizations, to come up with harmonized standards. So the idea, especially with the so-called standalone high-risk AI systems regulated in Annex 3, is that the provider has to assess the conformity of the AI system. Of course, the provider can use its own systems and own criteria to check compliance, but what is more likely is that the providers will follow these harmonized standards, because once there is a harmonized standard, then if a provider follows this harmonized standard, there is the so-called presumption of conformity. What does it mean? It means that if you, as a provider of a high-risk AI system, follow harmonized standards on data quality, human oversight, transparency, and so on, then you're on a safe side, because then it's presumed that your AI system is in conformity with the AI Act. Now, that's the good side. But the bad news is that the harmonized standards have not been made available, because CEN and CENELEC are on the way to develop them, there is also quite a kind of a strict deadline. I think it's May 2025. But even if they really make it until then, I doubt whether this will really produce legal certainty. Why? Because the European Commission has requested CEN and CENELEC to develop harmonized standards for all kinds of use cases. So we will have horizontal harmonized standards for transparency, human oversight, and so on. But I mean, human oversight means totally different things when we talk, for example, of medical AI or of autonomous driving. Now, autonomous driving would mean that you as a human can stop the machine. In the field of medical AI, human oversight means that the physician has an understanding of the output of the machine, can interpret it, and maybe correct it. So therefore, standardization is a good thing, I think, but there must be done quite a lot on the part of the European standardization organizations, that there are enough harmonized standards that then company also can use to be on the safe side.
Thank you. And maybe to you, Mr. Williamson, a couple your views on co and self-regulation of AI, the main benefits of this, and how you see, or if you think that the AI Act sufficiently leverages this possibility.
I think all I'll add on self and co-regulation is that it might be good for that to be, in a sense, competitive. We're at an early stage, and I don't think that's what's envisaged, but where different providers are maybe developing their own standards, where perhaps government agencies are helping them with that, where universities are involved. And we see that, for example, with the testing of capability of AI models, where there are various metrics, and they will have to evolve quite fast. Now, it's not really a safety thing as such, but in terms of assessing the performance of models, as the models become more capable, you'll need different kinds of tests. So you want that to be a fairly open field. Yes, you can standardize, but you don't want to lock it down too much, because they're going to have to continuously evolve. On the other point about automated decision-making and human participation, I think the answer is it depends. There are some systems where the last thing you would want is human participation, and there are others where you absolutely would want human oversight. So I think the presumption that you always want the opportunity for human participation is probably wrong. And if you watch the countdown of a rocket launch, you'll see that in the last, I'm not sure how many seconds, they'll say going to automatic, which means they're basically taking the humans out of the loop. It's happening too quickly for humans to make a decision. And I think there will be many examples where actually putting a human in the loop would greatly increase the risk. There'll be others where we probably do want a human with the override. Okay.
Fine balance to strike on this, certainly. I see we have actually one minute left, so I would close this session by asking each of you the same question, namely, what would be your main recommendation or recommendations to regulators inside Europe and outside Europe when it comes to AI regulation? Maybe Professor Ebers, you want to start?
Inside the EU, we have already now the AI Act. So therefore, what is necessary to look now into a meaningful implementation. And second, what is also necessary is that we need a revision of sector-specific EU laws, because there's so much overlap, inconsistencies between the AI Act and all kinds of other EU directives and regulations that apply additionally to the AI Act. The recommendation to lawmakers outside the EU, I think, that I made in my paper and also in my presentation is pretty clear. Do not follow blindly the EU's AI Act, but look into your specific need. And I think risk-based regulation is indeed a good approach to address risks, but only if it is made in accordance with a truly risk-based approach.
Thank you very much.
I think my comment will be focused on those outside the EU, because I think, you know, the challenge within the EU is to interpret the Act in the most sensible possible way, and I'll leave that at that. For those outside, I would say there's a big and ongoing challenge of adapting to AI to make the most of AI, and that should be the focus. And that will be a challenge to the machinery of government, and probably governments are not thinking deeply enough about that problem. So I would say that the bottom line is adapt, don't preempt, and wait and see. I don't think we need a law of AI. Opinions on that may differ, but nothing catastrophic is going to happen in the short run if you don't have one. You have existing regulation.
Well, thank you so much, Professor Ebers and Mr. Williamson. I think we are all much wiser after 1 hour of discussion, so that's great. Thank you to our audience for joining us today.